This maintenance worker slipped on a boat and thought his case was over. But what the Supreme Court decided changed 40 years of maritime law in California overnight. Brian Ranger was just doing his job at Alamitos Bay Yacht Club when everything changed. While boarding a vessel, he slipped on an uneven, slippery surface and fell, suffering serious injuries. If his case had been dismissed, thousands of maritime workers would have lost their right to federal protections forever. Every dock worker, boat maintenance crew, and marina employee in California would have been affected. When Ranger tried to sue under federal maritime law, the courts initially shut him down. The Los Angeles County Superior Court dismissed his case. The Court of Appeal agreed, ruling that California's workers' compensation was his only option. What the California Supreme Court discovered in February 2025 stunned legal experts, a hidden conflict between state and federal law that nobody saw coming. Corporate defense attorneys said he had no chance, until 7 Supreme Court justices unanimously took his side. But before I show you how this maintenance worker's simple fall rewrote maritime law, let's go back to that fateful day in 2018. He was just a yacht club maintenance worker with a family to support. His job included painting, cleaning, maintaining, repairing, unloading, and mooring vessels, the kind of essential work that keeps California's maritime industry running. But his persistence would give maritime workers across California a legal protection that even the state's most powerful corporations couldn't take away. For decades, injured maritime workers were forced to accept whatever their state workers' compensation would give them, no matter how inadequate, no matter if negligence caused their injury. Ranger's case traveled all the way to the California Supreme Court. The key question: could state workers' compensation laws block access to federal maritime protections? Legal experts were divided. As one court noted, the issue of federalism in admiralty and the scope of application of state law in maritime cases is one of the most perplexing issues in the law. On February 27, 2025, everything changed. The California Supreme Court ruled that the Court of Appeal had made a critical error. They determined that the 1984 amendments to the Longshore and Harbor Workers' Compensation Act did not eliminate maritime remedies for workers outside its scope. Even more importantly, under the supremacy clause of the federal Constitution, California's workers' compensation exclusive remedy provision could not deprive Ranger of his substantive federal maritime rights. What does this mean? If you work in or near California's waters, you now have stronger legal protections. You can't be forced to accept only workers' compensation if you're injured due to negligence on navigable waters. The Supreme Court reversed the judgment and remanded the case for further proceedings, giving Ranger the chance to pursue his claims under admiralty jurisdiction. All because one maintenance worker refused to give up when he slipped and fell on a boat. If you know someone who works near water in California, share this video. They need to know their rights just got stronger. If you know someone who works near water in California, share this video. They need to know their rights just got stronger. Please like, share, and subscribe for more updates.